all associated facts contained in paragraph 22, 33, 78. Order of this honorable court striking out paragraphs 20, Roman 2, 33 to 78 of the petition for not being in support of any valid ground in the petition. 4. Order of this honorable court striking out paragraph 21 to 27, 29 to 100 of the petition for being non-specific, lacking in clarity, generic, nebulous, vague, speculative, and gold-digging, in contravention of the first schedule to the Electoral Act. In the above applications, all the respondents relied on the provisions of paragraph 4, sub 1, sub D, and sub 2 of the first schedule to the Electoral Act, and variously argued that the paragraphs of the petition which they have listed are liable to be struck out for being vague, generic, imprecise, and nebulous. So arguing they relied on several cases which are cited here. By contrast, the petitioners have submitted that the respondent's objection in the listed paragraphs of the petition are not vague, nebulous, sufficiently pleaded. On this point, the petitioners cited several cases which are reproduced here. Petitioners further argued that the facts in Belgore and Ahmed, Piazu, and Oti, Ogu and Ekwere Madu, Ojukwu and Eradua, PDP and INEC and others, and Sogan Igwedi, and all other cases cited by the respondents are not the same with the facts of this petition. Those documents were never pleaded by reference or incorporation in those cases. Additionally, petitioners have relied on paragraph 17.2, first schedule to the Electoral Act 2022, and argued that the respondents have joined issues with the petitioners on those paragraphs. Having failed to seek for further particulars, they must be taken to have understood the said paragraph. Having failed to seek for further particulars, they must be taken to have understood the said paragraph. They relied on some cases that are reproduced. Now, resolution. I've carefully considered the submissions of the parties and the judicial authorities cited. It is right that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. General principle of law is that such pleadings must sufficiently and comprehensively set out material facts so as to ascertain with certainty and clarity the matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary of the case he is to meet and to afford him the opportunity to properly respond to such case. Its aim is to bring to the knowledge of the opposite side and the court all the essential facts. Therefore, it safeguards against element of these should be purposes. Dominic Kane, Odom, and others versus PDP and others. Lassan and another was Ishaq, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based, the relief sought by the petitioner, unquote. Paragraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively. In addition to the provisions of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019, subject to such modifications as would bring same in conformity with the provisions of the Act. By Order 13, Rule 4 of the Federal High Court Civil Procedure Rules 2019, every party to an election petition shall ensure that governments in their pleadings, and I quote, contain in a summary form the material facts on which the party pleading relies be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offences in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4, sub 1, sub D of the first schedule to the Electoral Act, and/or Order 13, with 4, sub 1, 5.
I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election, non-conclusion of election, thumbprinting of ballot papers, falsification of election results, widespread disruption, irregularities and malpractices without providing particulars or the polling units where the alleged malpractices took place. The lower court was therefore right when it held as follows. Above the paragraphs above, in my view, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the governments in the pleading must not be general. It must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above, and I adopt it as mine. Unquote. Indeed, on the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act relating to further particulars, the Apex Court held in PDP versus INEC Supra that, and I quote, an applicant for further particulars is merely a shield in the hand of the party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary particulars as the appellant's petition was in the instant case. Unquote. A sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings in paragraph 4, sub 1, sub D of the first schedule to the Electoral Act 2022 on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17, sub 1 and sub 2 of the first schedule to the Electoral Act 2022 relating to further particulars on the other hand shows that whilst in cases such as Abubakar versus Erdogan, on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 of 1
first schedule, Electoral Act 2022 relating to further particulars, on the other hand, shows that while in cases such as Abubakar versus Erdogan, Ombugadu versus Sule, the Supreme Court had held that a respondent who complains of vagueness of governments in an election petition should avail himself of the provision of paragraph 17 sub 1 schedule to the Electoral Act, seek for further particulars above size generic. Such governments will be incompetent, liable to be struck out. So also on this issue, it is therefore clear that the state of the law, as could be deduced from the various decisions of the Apex Court, is that the provision for further particulars, as stated in paragraph 17.1, first schedule to the Electoral Act 2022, will only come into play where the petition itself contains material or necessary particulars. In other words, paragraph 17 sub 1 of the first schedule to the Electoral Act 2022 does not bar a respondent from applying under paragraph 4 sub 7 of the first schedule to strike out arguments in a petition which are grossly inadequate, insufficient, devoid of material or necessary particulars. This is because the operational words in paragraph 17 sub 1 is further particulars, and this means there must be some material particulars already pleaded in the petition before further particulars can be sought by the respondent. As born from the Apex Court decision in Belgore Ahmed, PDP, INEC, and EPLZO and OT, the law is clearly settled that specifying the particulars of polling units or places where irregularities are alleged to have occurred are material particulars in an election petition. Governments in an election petition which allege irregularities or malpractices but fail to specify the polling units or places where the irregularities or malpractices occurred are bereft of material particulars, and such governments are incompetent and liable to be struck. As specifically stated in PDP and INEC, the petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against the respondent in order to cure the incompetence of such government. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, EPLZO and OT, and several others, on the mandatory requirements for stating material facts as provided in paragraph 4.1, first schedule to the Electoral Act. Contrary to the contention of the petitioners, the decision of the Supreme Court in Ombugadu and Sule Supra has merely reiterated the legal position relating to further particulars as provided in paragraph 17 sub 1, first schedule to the Electoral Act 2020. It has not departed from the above specific decisions of the Apex Court on the materiality of specifying in an election petition polling units or places where irregularities and malpractices are alleged to have occurred. Now, a look at the arguments in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular polling units or specific places where the alleged irregularities and malpractices have occurred. For instance, in paragraph 9 of the petition, where the petitioners averred that, and I quote, in appropriate cases, these agents raised complaints about anomalies where they occurred and reported such complaints to designated officers of the second respondent and the first respondent, unquote. The petitioners failed to specify the anomalies, the places where the anomalies occurred, the agents who complained, and the designated officers of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, where the petitioners allege that the first respondent, and I quote, suppress the actual scores obtained by the petitioners by deliberately uploading blood from EC8As on the RF in 18,088 polling units. The petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling unit codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. Paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, unquote. They did not specify the polling units where they allege there were no elections. Incorrect results that were uploaded and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, unlawfully reduced and added by the first respondent to the scores of the second respondent, unquote. They failed to state their scores that were reduced and added that of the second respondent by the first respondent, and the figures that shows that the first petitioners won the election. In paragraph 72, 73, 76 to 78, where the petitioners allege overvoting, they merely stated that they will, and I quote, rely on the forensic reports of the election materials showing that the votes cast in the polling units in Ekiti State, Oyo State, Ondo State, Taraba State, Osun State, Kano State, Yobe, and Niger States exceeded the number of votes accredited on the beavers in those states. Petitioners failed to specify the polling units in those states where the overvoting occurred, the number of votes affected, the margin of lead, which they claim that the voters who ought to legitimately vote in those polling units. In paragraph 73 of the petition, petitioners only stated that they will, and I quote, show that in the computation and declaration of the results of the election, based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation. Petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. Paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on from EC8As to establish that substantial votes were unlawfully credited second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic/expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection reports, and forensic/expert analysis was attached and served along with the petition on the respondents. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petitioners. It is only in paragraph 62 and 64 of the petition where the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. That the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondent, and also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondent. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details, polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, inflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners alleged corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practice. While standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is your reasonable doubt. The PDP INEC, Mohammed Wamako, Code of Customs and Excise versus Alaji Ibrahim Barrow, citations on the record. It is instructive that in paragraph 3.2, 3.21 of their submission, in opposition to the first respondent's objection, petitioners appear to have conceded that in the affirmation of the petition, they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specify the figures of the votes or scores which they alleged to have been suppressed, inflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets and forensic analysis reports which they have incorporated and made part of the pleadings by reference. See particularly on this paragraph 67 of the petition. Petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17.1 and 2 of the first schedule to the Electoral Act, they are deemed to have understood those amendments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as a winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in his defense. Indeed, in all the cases of EFCC RAIN, Ekpomo Polo versus Edere Moda, Marine Management Associates Incorporated versus NMA, and Dinjadi and Omako Supra, which were relied upon by the petitioners, the documents which were incorporated as part of the pleadings by reference were served along with the pleadings on the adverse party. In considering a similar scenario, this court by Ayola, JCA, as he then was, held in Nigeria Merchant Bank PLC versus Ayedu Investment Limited as follows, and I quote, "Before I part with this appeal, it is pertinent to advert to one question raised in this pleading regard to the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such arguments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this suit. Although the principle is established that if an agreement in writing is referred to in a pleading, it becomes part of the pleading, and it is open to the court to give the agreement its true legal effect, irrespective of the term used in the pleading to indicate such effect. That proposition of law should not be used to cover such argument as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered at the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as bank benefits versus Petitions Limited, ought to be defined, unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondent, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4, sub 5, sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, unquote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence. You are referring to documents prepared by the petitioner's witnesses. In other words, the spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have to obtain by subpoena. Being the petitioner's own documents, they ought to have served those documents along with the petition on the respondent, so as to enable the respondent to counter same by engaging their own experts to appropriately respond to same if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents, having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, as he then was, now JSC, held in Udiaga and another was Omegara, as follows, and I quote: the argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort to pinpoint in the pleadings the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, massive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? The arguments in the appellant's pleadings should have contained details of the allegations and complaints to which the respondent could reply in detail in their own pleadings. The appellants expected the respondents to reply to the various specific allegations contained in the witness statements filed along with the petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. The pleadings must show the facts disputed, while the witnesses will give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the
place of necessary affirmance in pleadings, unquote. Indeed, in the presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states, and the Federal Capital Territory, it is unimaginable that affirmance in the petition which merely allege irregularities and/or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for further particulars. See Belgore, Ahmed, and PDP. More so, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. See Busari versus Adepoju, Oyetola versus Adeleke, and Anazongu versus Onubogu, citations on the record. It is in this respect that the petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of a party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enam and others versus Adu. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4, sub 1, sub D of the Electoral Act 2022. In accordance with paragraph 4, sub 7 of the said schedule, the said paragraphs are consequently hereby struck out. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, the petitioners have in paragraphs 65, 67, 70, and 71 stated that they will rely on the report of the inspection. Additionally, the first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with the Electoral Act 2022. They have also alleged that they have scored majority of lawful votes cast and should be declared the winner. Relying on some cases which are produced here, the first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5, sub 1 and sub 2 on the other hand, for being inconsistent. Conversely, the petitioners contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They refer to the alternative reliefs at pages 35 to 37 of the petition and relied on some cases which are reproduced here, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adigije versus Nwaugu and others, this court, Ogun Wimiju Jesse, as he then was, held that, and I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance and in the same breath claim that he won the election by votes. The petitioner may plead the same set of facts to ground alternative reliefs. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief as the party must decide which relief is best supported by the evidence on record, unquote. See also on this Metal Construction West Africa Limited versus Aboderi, citation given. In any case, the first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, wherein the petitioners averred that the first petitioner was duly sponsored by the second petitioner, on whose platform the first petitioner contested the election. I therefore have no hesitation in discountenancing this ground of the objection. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. The second category of the respondent's applications that challenge some of the grounds of the petition and or the competence of the petition are as follows. First, respondent's motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 33 to 79 and reliefs 5, Roman 1 and 2 of the petition on transmission of election results for being cut off by issue estoppel. 2. Order striking out paragraphs 20, Roman 1, 21, 23, 24, 25, 26 and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2 and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds which are reproduced herein. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estoppel, as well as the issue relating to competence of are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in the substantive case. See Nwanko and others versus Eraduam. Ocholi on Onojo James, SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's locus standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, to the respondent's replies, or to some paragraphs of the petitioner's replies. Lack of locus standi of the first petitioner. The second and third respondents and the fourth respondents in their motion filed on the 8th of May 2023 also objected to the first petitioner's locus standi to bring this petition. The principal contention is that the first petitioner was in contravention of section 77 sub 3 of the Electoral Act 2022. They argue that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022 to join the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members of the second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act 2022. And since the first petitioner is not in the membership register submitted by the first respondent by the second petitioner, the first petitioner lacks the locus standi to challenge the outcome of the presidential election. Per contra, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned, and the courts lacks the jurisdiction to entertain them. They relied on the cases that are reproduced here. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of the political party. It is not a justiciable issue, and courts have no jurisdiction to entertain them. Say Enang versus Asukwo, and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioners. The provision of Section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its primary, invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, the first petitioner has satisfied the requirement of being a member of the second petitioner as provided for in Section 131 sub C of the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership of the second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. The first respondent in his motion of 19th of April 2023 and the second and third respondents as well as the fourth respondent raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election. The petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. They place reliance on JGD and INEC, Buhari and Obasanjo, citations on the record. In opposition, however, the petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to a petition, and the petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party. By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Eradua, Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties to an election petition. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing, is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate 2 or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of JGD and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution, he would have ceased being a governor of Yobe State if the case made out in the petition that he could not combine the offices of governor of Yobe State and acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku and the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition, and the petitioners herein have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. More so, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CA-PEPC 05-2023, which, as mentioned in the earlier part of this ruling, this court has consolidated with the petition in line with paragraph 50 of the first schedule to the Electoral Act 2022. This ground of objection to the competence of the petition is unmeritorious. It is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the reliefs which the court can grant in an election petition are statutory, as provided in section 136, sub 1, sub 2, sub 3 of the Electoral Act 2022. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are: first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply to the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 of the petitioner's reply for offending the provisions of the first schedule to the Electoral Act 2022. Second and third respondents' motion filed on the 13th of May 2023 seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply to the fourth respondent's reply, as well as the witness statement on oath for failure to deny the fourth respondent's allegations. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply to the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply to their respective replies, or in the alternative the paragraph thereof, which they have variously listed above. Their essential contention is that the replies, or in the alternative the paragraph thereof, have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or rehash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1, A and B of the first schedule to the Electoral Act 2022. The respondents replied on several judicial authorities, which are reproduced here. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent with the Electoral Act 2022. They relied on Silva and INEC, PDP versus Ezo-Onguka, citations on the record, and urged the court to discountenance the objections of the respondents and uphold the petitioner's replies. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote: if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, unquote. By the import of paragraph 16 sub 1A of the first schedule, the petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16(1)(a) are, quote, new facts, grounds, or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awodu Yilemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, "A new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new to the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its content and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation, and the defendant's averment was introduced to the pleadings for the first time and therefore unique and novel to his pleadings." Unquote. A careful examination of the petitioner's petition, the first, the second and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, the petitioners also introduced new facts in their replies to the respondents' replies which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A of the first schedule to the Electoral Act 2020. Paragraphs 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in the petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by Section 36(5) of the Constitution of the Federal Republic of Nigeria, 1999, since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC and others, Maku and another versus Al-Makura and other citations on the record. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraph has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition, it is only a response to paragraph 7 and 8 of the petition. But the petitioner's averment in the same paragraph 15 that the first respondents' officials at the polling units failed to give clear copies of the results of the election from EC8A to the petitioner's agents, as the pink copies given by the petitioner's agents were very faint and unreliable, is a new fact which tends to amend the petition. Paragraph 16, Roman 1 to 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purport to respond to new issues in paragraphs 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply to the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply to the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. the said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck out. Similarly, the petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24 contain serious allegations to the fourth respondents, which the fourth respondent has no opportunity to respond. Being in contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck out. And that indeed is the rulings on the respondents' objections, various objections raised.
Well, as I was trying to explain earlier before we went for the break, we'll take all the judgments. After that, my learned give their own decisions on the petitions in order to save time. Because the petitions are consolidated. So now we'll go to the main petition, in petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 25th February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition in determining the merit or otherwise of the petition in the interest of justice. At trial, the petitioners opened their case with tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the stage of final address. The said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents to file separate addresses on their objections along with their final addresses. In proof of their petition, the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses to give evidence and adopt their witness statements on oath and reserve the rulings for their objection to the stage of final address. Without prejudice to the objection, the said witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. The fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and exchanged their respective final addresses, including separate addresses in support of their various objections which they raised during trial. So we shall now consider respondents' objections to the competence of some of the petition witnesses and to the documents tendered by them during trial. To save time, we'll skip the addresses of counsel and we'll go to the resolution of those issues. So the resolution of the respondent's objections to witnesses and documents is contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenge the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath, on oath of those witnesses of the petitioners were not front-loaded along with the petition, but were only filed during trial, contrary to paragraph 4, sub 5B of the first schedule to the Electoral Act 2022. Section 285, sub 5 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. In the same vein, Section 132, sub 7 of the Electoral Act 2022 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the contents of an election petition which shall be filed. In particular, paragraph 4.5 of the state schedule mandates as follows. The election petition shall be accompanied by A list of the witnesses that the petitioner intends to call in proof of the petition, B, written statements on oath of the witnesses, and C, copies or lists of every document to be relied on at the hearing of the petition. But subparagraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14 sub 2 of the same first schedule to the Electoral Act then provides as follows. After the expiration of the time limited by A, Section 132 sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 contained in the original election petition file, or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to the statements of facts relied on to support the ground for or sustain the prayer in the election petition. And sub B, paragraph 12, for filing the reply, no amendment shall be made. 1. Of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, effecting any substantial alteration to, in or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian and other versus Mimiko and others, by Ogumbi JC, Oba and Vincent Ararume and others, and Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the Apex Court, par Ogumbi JC, held as follows in the court. By paragraph 4, 1 and 5 of the first schedule to the Electoral Act, a composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than a surreptitious attempt to amend the petition. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available which were not allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limit allowed for the presidential election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, video paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134(1) of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart and mind. The use of the word shall in paragraph 14 sub 2A of the first schedule to the Electoral Act is mandatory and places a complete bar on any form of amendment to a petition file and does not allow for an exercise of discretion whatsoever. Further still, on a critical result of the application, relief 2 seeks court to call additional witness to which AEO. It is pertinent to state that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285(5) of the Constitution and section 134 laws of court. In his concurring judgment in the same case, Nguta, JSC, specifically stated as follows, I quote, the additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts found by endorsed by the lower court. This court will not interfere with a concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court. Petitions are time-bound and the court will not allow a party to resort to any sort of subterfuge or to frustrate the intention of the Electoral Act that petitions be disposed of expeditiously. The petitioners in this case have relied on the earlier versus Ete and Lasun versus Awoyemi Supra to argue that the subpoenaed witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are subpoenaed witnesses who do not work for the petitioners. However, it is pertinent to observe that unlike in the present case, the subpoena issued at the instance of petitioner in the case of Omidran and Ete and Lasun versus Awoyomi were decided under the Electoral Act of 2006. Provisions similar to paragraph 4 sub 5, first schedule Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those introduction of section 285 subsection 6 of the 19th Constitution of Federal Republic of Nigeria 1999, which mandates that an election within 180 days from the date of filing of the petition. Thus, whilst this court in Omidran and Ete and Lasun versus Awoyomi appeared to have adopted a flexible approach, the Apex Court had taken a strict approach in its latter decision in Oke and Mimiko. Indeed, in subsequent following the Apex Court's decision in Oke and Mimiko, this court, per Agim JCA, as he then was, now JSC, highlighted this strict position of the law in Ogba versus Vincent at paragraph 46 to 48, paragraphs A to B, wherein he held as follows, I quote, I think that this court in Omidran and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omitiran's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006. The provision in the first schedule on prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rule where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and Court Practice Directions as overriding the rules of court in election court cases. In Mexico, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. The law, as laid out stima juris in Oke and Mimico, is that a witness deposition that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to the termination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored to that procedure, close of court. The firm position of the Supreme Court, as stated in Okia Mimico and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 285(5) of the 1999 Constitution, Section 137, Subsection 7 of the Electoral 2022, and paragraph 4, 5, and 6, and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 285(5) of the Constitution of the Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of a witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or supine witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court stressed this position. Our learned brother Bolaji Yusuf Jesse stated that, quote, from the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitled the appellant to file their statements on oath outside the time set for filing a petition, or a reply to the respondent's reply in answer to the petition. Of the humble view that whether an expert witness or not, a witness remains a witness. Though the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court Civil Procedure Rules 2009 made applicable to an electoral first schedule to the Electoral Act provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil form 1A before the filing of the statements of such witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to its provision. The subsidiary legislation must conform with the principal law, CNNPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandatory provisions of Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, sub 1, 5, and 14.1 and 2 of the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rules 3.1 of the Federal High Court Civil Procedure Rules 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the Section 285.5 of the Constitution, paragraph 4, 14.2, and 16.1 of First Schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use or exploit to overreach the respondents. That is the stand of the Supreme Court in Oke and Mimiko, number 1 Supra, followed by this court in Oba and Vincent Supra, close of court. Again, in Ararume and another, but and Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. It therefore means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the First Schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition, close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or expired witnesses, and whether they are willing or subpoena witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Nyechi Ipiazu, SAM, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a subpoena witness, Ama Ibom Abu, PW2, on the same ground that the witness statement on oath of the said witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoenaed witnesses in election petitions, stated by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13, 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed by filed at the registry of this court by the Petitioner Council, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued the subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by summons as stipulated in paragraph 42, sub 1 of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. It is clear from the provisions of that paragraph that it is a person summoned by the court suo motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, 2 flash drives containing third annual consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is a staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is a staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Today, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services, Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services, AWS, health dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious, please. This is a serious matter, it's not a laughing matter. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the president election on 25th February 2023. PW8, who claimed to be a cybersecurity expert, engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as Exhibit PCR, was, however, addressed to him personally and not through INEC. It is pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent are accordingly struck out. With regard to the respondent's objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondent is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PEF2, tendered through PW4. Exhibits PCG1 and PCG2, tendered through PW5. Exhibit PCH1, tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, tendered through PW7. And PCK2, tendered through PW8. The said exhibits I have estimated them in this judgment. The respondent's essential argument is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4(5)(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoenaed witnesses whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4(5)(b) of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be exchanged from the record. See the case of Buhari and INEC. The petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from the bar pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by what has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it is stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Admissible when giving its final judgment, even if that will amount to overruling itself by so doing. Shanu and AfriBank by UY4 JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph B to A, restated the position of the law that Even when pieces of evidence had been improperly received in evidence, the trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondent to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1 to PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83, subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that, as provided in Section 83, subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court, that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. Thus, in Ladoja and Ajimobi, where the Supreme Court, by Peter Odili, JSC held as follows, I quote, in respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards to the phrase, a person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91, subsection 3, which is now the Section 83.3. I think the phrase, a person interested, ever more so has been quite definitely put in the case of Halton and Halton to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings and therefore would have no temptation to pervert the truth to serve his personal or private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest. CPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence and 2011 held thus. By the provision of Section 91.3, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding and therefore will have a temptation to pervert the truth to serve his personal or private ends. In fact, it is in its most recent decision in Oyetola and Another versus Anet, the Supreme Court, per Agim JSC, restated this position in the following words. The other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis and carried out the analysis from the conclusion that the results were invalid to justify to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents to be relied on to prove the petition show it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition when the petition was anticipated to establish that the election result was invalid is not admissible evidence by virtue of Section 83(3) of the Evidence Act 2011 as amended. Close of court. In the instant case, PW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by a second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced initially 2023. His report was made a day before this petition was filed, on 20th March 2023. Obviously, the report Exhibit PCD1 to PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, she admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. She also admitted that the report she presented in Exhibits PCA are public information hosted by Amazon, which she downloaded from Amazon. Open access information she did cannot be amended by her. This shows not maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent he was as an expert on 10th March 2023 and that he produced a preliminary report on 17th and 18th of March 2023 and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are persons interested in the outcome of these proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, she is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, exhibits PCD1 to PCD3, PCE1 to PCE4, PCF to PCG1, PCJ1, PCF. In view of the foregoing, exhibits PCD1 to PCD3, PCE1 to PCE4, PCF to PCG2, PCH1, PCJ1, PCJ2, PCJ3A to F, PCJ4, PCK1, and PCK4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby extended from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. PCC 28, which include Adamawa State, are actually Beaver's reports and their certificates of compliance. That of Adamawa is PCC 21. In short, no certificate of compliance was produced by the first respondent in respect of exhibits PBP1 to PBP21. The Blood IRF reports exhibits ECA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from ANIC's IRF portal and were certified by ANIC as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANIC authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixon, where the Apex Court held that the computers from internet-generated documents printed from the website of a public institution is a public document, and only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 is admissible. For that, I've cited the victim of the Supreme Court by Akas JSC in support. Exhibits PBP1 to PBP21, having been downloaded from ANIC report and duly certified by ANIC, are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive tendered by PW5, staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2020 final report, as rightly observed by the fourth respondent. The photocopy of the document is certified by the Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, the secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of same to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it, as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and where he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. See Omisori and Arebashola, Emmanuel vs. Umana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. There are so many, they have been listed in this judgment. You get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to CCC of that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore and Ahmed, Ipiazu and Oti. In the latter case of PDP and ANEC, the Supreme Court was categorical on this mandatory requirement of specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling points, disruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars or the polling units where the alleged malpractice took place. The lower court was therefore right when it held as follows. The paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the averment in the pleading must not be general, it must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. Thus, where allegations of non-compliance and corrupt practices are made, such as in the instance the polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred, must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent to its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, and PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practice, and the same set of facts are pleaded for both. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, to which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Ekiti, Oyo, Ondo, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioners failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioner failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blurred results downloaded from RF and contained in 4 boxes. The petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units to which those blood reports relate is an impossibility because the results are unreadable and the details of most of the polling units are stated in Exhibits PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report, or PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. Did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints led even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7. The petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner, and the conduct of the election thereof, acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form upon the first respondent agents duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioners' contention that they have complied with paragraphs 4, 5C, and 41A of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the respondent objection to petitioner's pleadings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials as stated in paragraph 41(1)(d) and 2 and 41(8) of the same schedule, so as to enable the adverse party to know the exact case he is to meet and to respond to same accordingly. As I stated in my report, which the petitioner stated they had to respond to same, but was merely tendered at trial. by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 ballot results relate, the said documents are clearly inadmissible. The said exhibits are hereby discountenanced and expunged from the record. We now go to petitioner objections to the respondents' documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, R5, 6, and 7 through its sole witness, Dr. Lawrence Bayode, the director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opeyemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objections to be adduced at the stage of final address. Pursuant to the order of this court, that parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondents. The written address in support of the objection of the first respondent's documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent document, Dr. Livy Uzoku, the learned senior counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits RA 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent documents, the petitioners raised the sole issue of whether, having regard to the said pre-hearing session report and paragraph 41(3) of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Learned Silk pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document being the person to tender the document, the witness of the first respondent, thus RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate at the same time, since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. Here we just go direct to the resolutions. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Idoziem and others, where the Supreme Court, Onogan JSC, held, as it then was, held that a private document sent to the police form part of the record and of the police, and is consequently a public document within the provision of Section 109 of the All Evidence